Okay, so today is Monday, November 24th, 2025, Section 2 of Admiralty. I'm going to be talking about a couple of oddities in Admiralty law. The first one is Rule B attachment. What is Rule B attachment? Well, first of all, what is Rule B? Rule B out of what set of rules? Well, the federal courts have a set of rules known as the Federal Rules of Civil Procedure. And they're numbered, not lettered. The main ones are numbered, 1 through, 60-something. And they describe every aspect of how to proceed, how to file a complaint, how much time you have to amend it, what types of pleadings you make in court, motions, everything. Then there's supplemental rules. And the supplemental rules are written just for Admiralty law cases, just for maritime stuff. So Supplemental Rule B is the one we're talking about. And Supplemental Rule B allows for something to secure a claim. Money can be tied up, the defendant's money can be tied up. It's a little bit like arresting a vessel, but you're not actually arresting a vessel. You could be attaching a vessel, but that's unusual. Usually you're attaching property. Sometimes real property, sometimes money in bank accounts, and for a brief period, in the earlier part of this millennium, you can attach funds that are passing through banks for a microsecond. And that's what we're going to talk about today. But Rule B is also known as quasi-in rem. In rem, remember, is where you have a defendant that is property itself. A vessel, for example, is an in rem defendant in a maritime case, very often. And we talked about this just last week with maritime liens. You assert a lien, you arrest the vessel, and then the lien against the vessel gets adjudicated, the claim that you have. It gives you the lien. Rule B is really in some ways similar, but in many ways very different. You don't actually have the property as the defendant. So it's not in rem in that sense. It's a way of grabbing the property and using it to secure your claim, just as you would in the in rem defendant case, but technically it's different. And so that's why it's called quasi-in rem. Quasi-in rem was a concept that was widespread in the law until somewhere in the 20th century, and the Supreme Court kind of knocked it down. One of the last surviving examples of it is this Rule B attachment. And it's pretty strong stuff because you can actually tie up money that belongs to a defendant even before you start to adjudicate the lawsuit, in much the same way as you tie up the ship. But in the Rule B attachment, no P&I club bails you out. That money is tied up. Now, what are the requirements? If you read the rule, you'll see, but we don't have to read the rule. Rule B attachment requires that you file a complaint with the federal court, and you make certain allegations and verify them. And you can only do it, interestingly, if the defendant is not present within the federal district. So if I want to tie up money that's in a Manhattan bank account, that's the Southern District of New York, if the defendant that I'm trying to attach the funds of, the defendant who has that money, if they're in New York, I can't do it. But if it's some foreign defendant, could be in Hong Kong, then I can do it. So one of the provisions of the rule is that the defendant is not found within the district. So it's a little antithetical. It's unlike with an in rem proceeding, the vessel has to be in the district. With the Rule B attachment, the defendant has to be not in the district, but their property is, and so you attach their property. So why would you want to do that? Well, suppose you have an arbitration, and even though you're not going to be in court on the arbitration, you're going to be in arbitration, I should say. Why would you want to tie up somebody's money? Well, because then you have security if you win, and you can actually do that. But here's the way it gets interesting, and this is a unique, like I say on the slide here, a unique New York story. By and large, most lawyers don't know this story. Maritime lawyers do. Certain banking types know about it. And it's basically history. It happened and it's over. But here's the deal. If you're going to do a Rule B attachment, first of all, the defendant is not in the district. Okay, fine. Is there a requirement that the subject matter actually have anything to do with the United States? No. And this is where it gets interesting. Because what happened is, some years back, and we can go to the next slide to look at that. We've already actually covered what's on this slide. It's not the same as the rest. Okay. Let's go to the next one. Well, here's the history. It's perfectly normal to tie up bank accounts. Rule B attachment of a bank account where money is sitting in a bank in the jurisdiction. So if I have an arbitration, and maybe it's in the Far East, it's a company in Vietnam versus a company in China, absolutely not going to be arbitrated in the U.S. Well, maybe it'll be arbitrated in New York, or maybe it'll be arbitrated in Singapore or London. But the bottom line is, using Rule B, I can march into federal court in the Southern District and tie up that money. The money that's sitting in the bank account that belongs to the other side in my arbitration, or a defendant in a foreign lawsuit for that matter. So, what about this? What about the fact that money transfers through banks in New York for a microsecond? The reason that happens is because New York is a world financial center. We even have a place called the World Financial Center. But New York is like the banking top of the pyramid. So certain banks, to transfer electronic funds, have to use higher and higher level banks, and it goes up and back down. And the top banks for that transfer, in many cases, are located in New York. So what does that mean? So could I conceivably do a Rule B attachment and attach funds that are passing through New York's banks for a microsecond? If I give the banks notice, if any funds get transferred to this entity through your account, their account with you, I want to attach them. I have a court order saying I can attach them. And you go to your federal court judge and get this order signed, and then you serve it on these banks, and even if you don't know which bank it is, serve it on all of them. And then if one hits, suddenly $1 million is tied up from that defendant. Would that be legit? Is that property within the district? Well, that's quite an interesting debate. It's not really here for very long. It's passing through for a microsecond. It's electrons passing through. But in 2002, in a case called Winter Storm, the Second Circuit said yes. This is property subject to Rule B attachment. So the Second Circuit, you'll remember, is the appeals court for the federal district courts that sit in all 4 New York districts, and the District of Vermont, and the District of Connecticut. Well, only one district mattered, because it doesn't happen anywhere else, and that's the Southern District of New York, because the banks are all in Manhattan. But in 2002, in a case called Winter Storm, the Second Circuit said yes, the funds that are passing through for a microsecond are property subject to Rule B attachment. And you can just imagine what this meant to certain maritime law firms. This meant that if you can build a client base in the Far East particularly, where these common denominator banks are separate from each other, but they merge in New York, you can roll out these Rule B attachment complaints like boilerplate, and just fill in the blanks and file them and make a lot of money in fees and tie up all this money because some outfit in one Far Eastern nation, a lot of it was China and Vietnam, the ones I saw, the company wants to litigate or arbitrate against an entity in another country in Asia, and they start building the network with these New York maritime firms, and the maritime firms just start attaching funds using this Rule B attachment procedure, and they attach money that's passing through. And it got very interesting. It was really a snowball effect, because these clients, these Asian maritime companies that were doing, chartering or shipping, could be cargo, any claim that was maritime enough to get a federal jurisdiction, they would hire these few law firms here in New York to do these Rule B attachments, and they'd be very successful because now they'd have tremendous leverage. Imagine if you have a claim against a company and you've tied up $1 million of theirs. That's a lot of incentive to settle and not wait around until the thing is adjudicated or arbitrated, right? It's like their money is being tied up. And the interesting thing about these funds, it isn't always their money, right? The money might be being transferred to them, but maybe they're getting it as an agent, and it's not even really their money. And then they have to put up their own money to cover it. And they could make a petition before the court to try to get that money freed up, but it's time consuming, it costs more money to do that. So it was a tremendously powerful tool. One could argue that it was actually somewhat violative of the Fifth Amendment to the U.S. Constitution that says private property will not be taken without due process. I mean, there was some process, but it was pretty light in terms of what it would take to tie up all this money. In any event, you'll see some of the high points here about what happened as that snowball got bigger and bigger. Somebody, I think the Second Circuit, when they reversed themselves in Jolly Shipping, which we'll get to in a minute, that's the case that overruled the winter storm case, they said it created strains on federal courts and international banks. Probably true. I don't know if the strains were that bad, because you know, the banks, they can handle it. As far as the federal courts, yeah, if you look at the next one, 1/3 of new filings by 2009. That was 7 years into it. Remember, winter storm that said it's okay to do this, that was 2002. By 2009, 1/3 of the new filings in the Southern District of New York Federal Court were Rule B maritime attachment cases. That's huge. Is that a strain on the federal courts? Probably not, because all they really were doing was rubber stamping these complaints and authorizing the taking of the money. So I don't know if it was such a strain, but it was a pretty huge number. The Southern District of New York is a big federal court with, you know, tens of thousands of cases filed a year. And by 2009, 1/3 of those were Rule B maritime cases. Who thought maritime law was so big? And most people, most lawyers don't know. Most federal lawyers don't even know that this happened and peaked by around 2009. But that was huge. For 1/3 of new cases in the Southern District, Rule B maritime cases, that was like phenomenal. And believe me, the judges did not like it. Whether it was a strain or not, there was something out of whack with it. So 4 months between October 2008 through January 2009, 962 new cases seeking to attach $1.35 billion of money that was just passing through New York banks for a microsecond, tied up, stopped here. I don't write it down here, but I used to joke about this. I said if American dollars were being tied up in some foreign country with this little due process, we would be sending troops. I mean, could you imagine? All this money is just getting tied up by the federal courts of the United States with questionable due process, and, you know, it's just, you can't touch your money, or maybe money that's being sent to you that you're going to use for somebody else. It's tied up. So it's not a good situation. The writs of attachment, those are the things that are served on the banks. By 2009, 800 to 900 per day. So yeah, the banks were getting a lot of this stuff coming in. I think they had it pretty well automated. I don't think they were spending huge amounts of time and labor to make it work, but still it was, you know, it was an extra resource that was being drained from the banks. This is probably true. Harmful to New York's credibility as an international banking center. Yeah, who wants an international banking center where when money goes through there, it might not get to the destination. It might just get stopped along the way by the federal courts of that nation, the United States. That's not good for the reputation of an international banking center. Oh, you can bank through New York with these common denominator banks, very high tech, very wonderful. Everything works fine, except sometimes billions of dollars get tied up because the court says, oh, okay. So that wasn't too good. I don't know if this is true. I'm not an international currency person. But the Second Circuit, when they overruled Winter Storm, they said it may even have the effect of making the dollar less useful as currency in international transactions. I don't know how useful the dollar is. We have a trade deficit, right? So the dollar is never strong, but that doesn't mean we don't have a healthy economy. I don't know, that maybe that didn't come in on the mic, but I don't know, the US dollar is what it is. Anyway, history was made, October 16th, 2009. The Second Circuit overruled Winter Storm, which was the 2002 case that said EFTs, electronic funds transfers, passing through New York for that microsecond are property subject to Rule B attachment. All they did is they said they are not property subject to maritime attachment. That didn't come in clear on the bottom. Let's see what happens if I move it down. Well, I guess bottom line is that the PowerPoint as viewed through Brightspace is not the same as PowerPoint as viewed through PowerPoint application. So I could redo this whole thing, but I'll just tell you, it just says EFTs being processed by an intermediary bank. Those are the banks at the top of the chain where the money has to pass through. They're not property subject to maritime Rule B attachment, and it gets blacked out on the bottom. Interesting, just a point of how appellate courts work, or at least the federal appellate courts, the consent of all judges on the Second Circuit in active service was required. They had to weigh in on it because they were overruling prior precedent in the Winter Storm case. Remember, Winter Storm in 2002 said EFTs, electronic funds transfers, are property subject to Rule B attachment. And so to reverse themselves, they had to get all the active judges involved. Nobody dissented as far as I know. There was an attempt to take it to the U.S. Supreme Court by the loser. That didn't go anywhere. But if you think about it, it would make no real sense for the Supreme Court to bother with it at all, because there will never be another circuit ruling on that issue. The only place it could happen is New York, and the Second Circuit ruled on it. So unless the Supreme Court felt very strongly that that was the wrong ruling, there would be no reason to jump in and say, oh, we don't want to have a circuit split with the other circuits, right? Because no other circuit is going to ever have that issue. It's a New York issue. It's a unique New York issue. That's a tongue twister, everybody knows. Unique New York, unique New York, unique New York. Okay, so anyway, bottom line is it ended there. Jolly Shipping was the end of the day. Shipping Corporation of India versus Jolly overseas, I should say. I often confuse them and say Jolly Shipping. The Jolly case. The lawyer on for the winning side was Jeremy Harwood. Knew him when he was at Healy and Bailey. He died rather suddenly while he was still barely in his 40s of a major heart attack. I think he might have been in his 50s by then. Very type A guy, so there you have it. But he won, and he changed the problem that had been mounting for 7 years. So from 2002 to 2009, in the Southern District of New York, in the city of New York, in the banking community of New York, billions of dollars got tied up on this Rule B attachment, and the money was funds being transferred through for an instant. And that's over. So I like to tell this story as an oddity of maritime law. In New York, it's a New York story. But remember, this is just the oddity. Rule B itself is broader than just electronic funds attachments. You can still tie up money that's sitting in a bank account in New York, not money that's transferring through. But if one of these defendants has money in a New York bank account and it's here and they're not within the district, you can use Rule B to attach those funds. Similarly, if they have real property, and often if they have real property, they're going to be found within the district for jurisdiction, so it may not be available. But the bottom line is any property in the district could be real property, could be, maybe a corporation has an artwork here or something in some museum that they own, and you could maybe attach that. But the best thing to attach, of course, is actual liquid money, because people need to put their hands on it. If you attach an artwork, okay, it's sitting in the museum, it's under attachment, the court has, if you want to do anything with it, the court has to approve that, but it's going to sit in the museum anyway, so who cares? Generally speaking, with attachments of property, I don't know, but attachments of physical property, I'm not sure that it gets marshals involved to go out and seize the property. I think for the most part, Rule B is used only for money anyway. So it's primarily attaching funds that are sitting in a bank account within the district, owned by a defendant who's not within the district, so then you can bring the Rule B complaint and attachment proceeding. But again, this thing about the electronic transfers being attachable, that was allowed in 2002 and then disallowed in 2009. And during that time, during that 7 years, it went from 0 to 60 in 7 years. It went from a relatively rare thing to, once the Second Circuit gave it approval in Winter Storm, it went to 1/3 of the new cases being filed with these Rule B attachments of electronic funds transfers. So you can see how big it got. So that's pretty much all I have on Rule B. I'm going to stop the camera now and check the time, and maybe we will talk about the other half of these maritime oddity items, and that would be Robbins Dry Dock in 5.